The subject of today's talk is the hasty, non-transparent and procedurally flawed exercise of revision of electoral rules in Bihar, what is called a special intensive revision exercise. It required the Supreme Court of India's intervention to tell the Election Commission of India that the fundamental principle of natural justice had not been followed, and that those whose names were removed from the electoral rolls, excluded from the electoral rolls, need to be told that they are not there because of this and this. Besides, this whole thing of 65 lakh voters exclusion, the names of those excluded have to be found on the website. It cannot be that it is some kind of opaque business. This is the essence of the Supreme Court of India's intervention just 3 or 4 days ago. I want to speak to you about my views and my perspective. First of all, I have no doubt that this Constitution says that we, the people of India, gave this Constitution. To that extent, all the constitutional functionaries, including the executive, legislature, judiciary, and all these people, including the Election Commission of India, are in a larger sense, responsible to us, the people of India, because it is for us that all this is being done. That is one perspective. I look at this from the perspective of the great legal dictum which has come down from ages, from centuries. The Roman law, it is not enough to be just. One must also appear to be just. That dictum speaks to a timeless reality, a timeless truth that has come down from Roman times. When Julius Caesar divorced his wife Pompeia, he famously declared, "Caesar's wife must be above suspicion." She may not have done anything wrong, but even the perception of impropriety was enough for Caesar to act. Why? Because in public life, the appearance of virtue matters as much as virtue itself. That is how the Roman ideal comes. Justice must not only be done, but also seem to be done. This is the perspective in which I see this obvious impression that people will get, the perception that people will get that things are not at all fair. That is the perception that we get, and that matters for a functioning democracy. There is another important principle that enunciated by Jürgen Habermas, German philosopher and social theorist, who argued that legitimacy flows from open, rational deliberation. An institution, like the present case, that hides its reasoning or cloaks itself in mystery, even if acting correctly or legally, loses moral authority. Moral authority. So, even in being right, opacity is a form of injustice. What is the impression that we have? The impression, and that's what I said, it matters. The present government, these are the facts, the present government promulgated the Chief Election Commissioner and other commissioners, Appointment, Conditions of Service and Terms of Office Act in 2023. And that was promulgated with the specific purpose of nullifying the Constitution Bench judgment of that year and bringing in that instead of the Chief Justice of India being a member of the committee that selects the Election Commission of India members, instead of the Chief Justice of India, the Cabinet Minister nominated by the Prime Minister would be a member. So, there is immediately an impression, everything might be legal, even this new provision substituting a Cabinet Minister for the Chief Justice of India for the selection process of the Election Commission might be legal because there is a statute or something, which of course is again the reality is that it is passed by the majority in the Lok Sabha, and the majority is by the ruling party. That apart, at least outside it might be illegal, it is, but the impression is there that there might be a pliable Election Commission of India, which does what the executive wants it to do. That impression might be there. The impression that the Election Commissioner of India is not free from the executive and is not independent. That impression, it is difficult to wish away because it is there. That is the sequence of events. Together with that, a fairly disturbing trend, not only for the Election Commission but also in a whole public life, the arrogance of the tone and tenor and the adversarial style of the Chief Election Commissioner's statement on this issue is just the opposite of sobriety and reasonableness required in our national discourse. It is a sign of the times that the Supreme Court of India has had to intervene in matters so fundamental. That is, natural justice demands that those who have been excluded must be given a chance